evening, everybody. Thanks for joining us again. Another one of our Safer at Home series talks. As I see by my chat, I want to give you a little message. Yeah, it was 1 year ago that we did our first virtual talk. And Dr. Paul, you're number 96 on the list. So you're not the first and you won't be the last. So these aren't going away. So thank you for joining us again. Before we get started, I want to remind you that all our talks are brought to you by Cape Cod 5, First Citizens Federal Credit Union, and Martha's Vineyard Savings. All the books on our series are available at Eight Cousins Bookseller in Falmouth, so we hope that you visit the local. And our guest tonight, Joel Richard Paul, is the Alfred and Hannah Fromm, a professor of law at the University of California Hastings Law School, where he teaches constitutional law and international economic regulation. Paul was also taught on the law facilities of Berkeley, Yale, the University of Connecticut, Leiden University in the Netherlands, and American University. He's currently finishing a book on the rise of American nationalism for the Civil War. Would you welcome our guest tonight, Joel Richard Paul?
Thank you very much, Mark. I appreciate the introduction and the invitation to be here today. When Mark first called me and invited me to speak to the Historical Society, I had hoped that I'd be able to see you all in person. In a normal year, I would expect I would probably be on the Cape at this time visiting my family who live in Harwichport. But regrettably, as we all know, it has not been a normal year for some time now. So thank you for the invitation to talk about Chief Justice John Marshall, our greatest Chief Justice, who did, I think, far more than most people realize to secure the rule of law and the independence of our judiciary. Over the last couple of years, following the publication of my biography of John Marshall, I've had a chance to speak to many different groups around the country. And frankly, I didn't expect this kind of response to a book about the Supreme Court. But the events of the last several years, culminating in 2 impeachments and the January 6th insurrection, have really, I think, shaken some people's confidence in the rule of law and in our judiciary. And I think folks are looking for some reassurance. It's always an occupational hazard for historians to draw historical parallels and to make predictions based on past experience. History may repeat itself, but historical patterns are not predictive. With that caveat, let me suggest the following. A wealthy presidential candidate launches a populist campaign against the cultural and political elite on a promise to disrupt Washington, to realign our priorities, to shake up our foreign alliances and trade relations. He attacks his opponent by spreading lies and innuendo. A foreign government intervenes in the election on his behalf, and he's swept into office on a wave of rural discontent. Once elected, he accuses his political rival of treason, disparages the press and the judiciary, and disrespects Congress and the norms of office. And the country becomes deeply polarized, and many Americans fear that the president threatens the rule of law and the Constitution itself. I'm speaking, of course, of Thomas Jefferson, who was elected in 1800 with the support of revolutionary France on a populist program to drain the Washington swamp, to replace the Federalist judges, to shrink the national government, to return power to the states. That was the situation that John Marshall faced when John Adams, who was a lame duck president in his final month in office, decides to appoint Marshall Chief Justice of the Supreme Court. Now, most people don't realize that Marshall didn't want the job, but he took it because nobody else did either. The US Supreme Court was a professional dead end. In 1800, the court heard an average of about 6 cases a year, and these were mostly cases of little consequence. Justices spent much of their time riding around the country, hearing circuit cases in taverns and sharing beds with strangers. The Supreme Court, in fact, was so insignificant that when they designed the Capitol, they forgot to build a courthouse. The Marshall Court had to meet in a nondescript Senate office building, the Senate committee room, rather, on the ground floor of the Capitol, which they shared with the district court and the circuit court. They didn't have a home of their own until 1935. Marshall and the Federalist judiciary faced an implacable enemy in President Jefferson. Jefferson had personal as well as political reasons for hating Marshall. Jefferson was Marshall's second cousin, and their families had bitterly feuded for 2 generations over the inheritance that Jefferson's father had appropriated from Marshall's grandmother. So as a result, Marshall grew up in poverty, and Jefferson lived in the largest house in Virginia with hundreds of slaves. Perhaps Marshall got even with Jefferson by marrying Polly Ambler, who bore a striking resemblance to her mother, who just happened to be the woman who broke Jefferson's heart when she rejected his marriage proposal. It fell to John Marshall in this situation to defend the independence of the judiciary against the Jeffersonians, who now control both houses of Congress, as well as the White House. The one thing people know about John Marshall is that he invented judicial review in the case Marbury versus Madison. Now, in fact, Marshall invented a whole lot of law, but the one thing he did not invent was judicial review. Some state courts had already asserted the power to strike down unconstitutional laws. It happened, for example, in Rhode Island. And in the ratification debates, it was generally accepted that the Supreme Court would have the power to declare laws unconstitutional. Not even Jefferson contested the power of judicial review. I'm sure that most of you have long since forgotten if you ever knew the facts in the case, but briefly, William Marbury was one of those midnight judges who was appointed by President Adams in the last hours of his presidency. And Marbury's commission as a justice of the peace for the District of Columbia got confirmed by the Senate and then signed by President Adams, his last day in office. And John Marshall, who was then the Secretary of State, applied the Great Seal of the United States on the commission. And it was up to John Marshall to then deliver the commission physically to William Marbury in the last hours, literally, of the Adams administration. But Marshall is completely preoccupied, and he doesn't get around to delivering the commissions for the justices of the peace before Jefferson is sworn in the next day by the new Chief Justice, who just happens to be John Marshall. Jefferson then finds the commissions in a stack on the desks of the office of the Secretary of State. And he orders his Secretary of State, who is James Madison, not to deliver the commissions. So Marbury doesn't get to be a justice of the peace, and he decides to file suit in the Supreme Court, asking the court to order Secretary of State Madison to deliver over his commission. Got it? So in the decision, Marshall first holds that Madison broke the law by refusing to deliver the commission to Marbury. And then, after holding that Madison broke the law, Marshall says, well, the court has no jurisdiction to hear the case anyway. You probably know that the Supreme Court normally does not hear cases like a trial court. The Supreme Court is a court of appeals, so cases get appealed up to the Supreme Court from lower courts. Marshall, in his decision, finds that the statute under which Marbury filed the suit granted the Supreme Court jurisdiction to consider orders like this at the trial stage. But, he says, Article 3 of the Constitution forbids Congress from giving the court this kind of jurisdiction. And therefore, he says, the statute that Congress approved is unconstitutional, and the court has no jurisdiction to hear the case, and they dismiss Marbury's suit. Now, none of this makes any sense. And the case has puzzled historians for generations for the following reasons. First of all, Marshall knows that courts are not supposed to decide the merits of the case if they don't have jurisdiction to hear the case in the first place. So why does Marshall decide to hold that Madison acted illegally in refusing to deliver the commission? Second, the plain language of the statute does not, in fact, give the court jurisdiction to hear cases like this. Marbury's attorney, Charles Lee, simply filed the case in the wrong court. He should have filed the case in the federal district court. He could have appealed up to the Supreme Court eventually, but he instead filed it in the Supreme Court. Now, Charles Lee is much too smart to make a mistake like that. So perhaps he misfiled the case on purpose. Third, William Marbury is a very wealthy man. He is the president of the one bank in the District of Columbia. He comes from a fabled Maryland family. The Justice of the Peace job is a lousy job. It's even worse than being a Supreme Court justice. It pays nothing. The job entails arresting prostitutes and drunks and deciding petty cases for less than $5. Now, there is no reason in the world to think that Marbury actually wants this job. Indeed, if he did want the job, he could have refiled his case in a lower court, but he didn't bother doing that. So what was his motive for bringing the case in the Supreme Court to begin with? Finally, Marbury could not prove that he actually got this commission. He couldn't prove that the commission was ever issued because the Secretary of State, Madison, refuses to participate in the case. Madison doesn't even show up at the trial. And so there's no obvious witness or evidence to prove that he's entitled to this commission, except for John Marshall, who, of course, sealed the commission, and he couldn't really be a witness in his own court. So what does he do? Marshall has his brother James, who happens to be a district court judge, sign an affidavit that attests that he was supposed to have delivered the commission, but he just forgot. Now, None of that is believable. None of that makes any sense. In my research, I discovered evidence that suggests that the whole case was a setup. Chief Justice Marshall, James Marshall, Charles Lee, and William Marbury sat down and plotted the case from the beginning to create a vehicle for allowing Marshall to assert the court's authority against the threat posed by the Jeffersonians. Charles Lee purposely filed the suit in the wrong court to give Marshall the opportunity to assert jurisdiction over the Secretary of State and to affirm that the court also had the power to strike down acts of Congress. Madison was so disdainful of the court that he didn't bother showing up in the trial, would have refused any order from the court to deliver the commission. It would have made the court look ineffective if the court had said to him, you have to deliver the commission. So instead, what Marshall did was he beat a strategic retreat. He avoided a confrontation with Madison and Jefferson while establishing a critical precedent that has survived 2 centuries. What Marshall did in Marbury was far more important than confirming the power of judicial review. What Marbury established was much more fundamental than that. In fact, it was the most fundamental principle of our entire legal system, that no one is above the law, not even the President of the United States or members of his cabinet. All of them are subject to the court's jurisdiction, and that even a president can be held accountable under the law. That is the essence of the rule of law. In cases like Marbury, McCulloch, Cohen, Martin, Marshall boldly asserts the supremacy and the independence of the judiciary at a time when Jeffersonians wanted to rid the judiciary of all Federalists. In fact, the Jeffersonians actually set out to impeach Federalist judges all over the country. Indeed, Jefferson went so far as to assert that he alone should have the power to hire and fire judges at will. Now, just imagine what our country would look like today if previous presidents had that power. Marshall's decision in Marbury versus Madison has obscured his other contributions to our legal system and to our Republican form of government. Marshall established the principle that federal law and treaties and federal courts are all supreme over state courts and state law. He interpreted Congress's powers to regulate commerce broadly in the hope that one day Congress would be able to regulate slavery out of existence. He declared that international law is part of our law and has to be read into every act of Congress. He defended the property rights. Of individuals and the rights of private corporations and colleges. Prior to Marshall's opinion in the Dartmouth College case, which some of you may know about, there were only a handful of private corporations in the United States. And within a decade after the Dartmouth College case, there were thousands. This was the first case in which the court established the principle that a private college or a private corporation had an independent existence. By the time Marshall had retired, there were more than 20,000 private corporations with a total authorized capital of $6 billion. That is his legacy. Marshall defined and defended the rights of Native Americans and upheld their right to occupy and possess their tribal lands from free from any interference by the states. Uh, and Marshall protected the rights of aliens, even the rights of enemy aliens, under our Constitution and under international law. All of this was Marshall's doing. In fact, no member of our founding generation has had a more enduring impact on what our republic has become than John Marshall. And no one did more than Marshall to preserve the delicate balance, the delicate union, rather, of our fledgling republic at a critical moment in time. Marshall's leadership really elevated the court and made it a co-equal branch of our federal government. But how does he succeed in doing that against the overwhelming power of the populist Jeffersonians and later the Jacksonians? Before Marshall, the justices had issued opinions in seriatim, meaning that each justice would issue his own individual opinion. There was no single opinion of the court. Marshall thought that the court had to speak with one voice, that creating one single unified voice would make the court more powerful. It was therefore necessary to hammer out a single opinion, to get all of these justices together to agree. And to that end, Marshall insisted that all of the justices share the same rooming house. For most of 34 years, the Supreme Court all lived together. They ate all their meals together. They especially drank together as a fraternity of brothers. I mean, it's really funny imagining the Supreme Court today living together and eating and drinking together. It sounds more like the plot for a reality TV show. But that's what Marshall did to create the kind of unity and consensus that he needed to make the court a co-equal branch of government. And as a result, over 34 years, the Marshall Court issued 1,129 decisions. All of those decisions, except 87, were unanimous. Imagine that. And about half of all of those opinions were authored by Marshall himself. So his legacy on the court, both as the longest serving Chief Justice and also as the author of so many of the most important decisions, is just staggering. What makes this record even more extraordinary is that every justice who was appointed to the court after Marshall was appointed by a Democrat Republican president who opposed Marshall's federalism. And yet, with his very powerful intellect and his considerable charm, Marshall managed to find common ground in almost every case and forge a unanimous opinion. Marshall had this incredible gift for inventing new legal concepts that made compromise possible. For example, he invented the idea that we have self-executing treaties and non-self-executing treaties, and the idea of dependent sovereignty. And these were just legal strategies he used for managing the conflict between Jacksonian democracy and the treaty rights of indigenous tribes. Where does this gift for legal creativity originate? Unlike all of the other great Virginia founders, Washington, Jefferson, Madison, Monroe, Lee, Marshall was born dirt poor. With his 14 brothers and sisters, he shared a 2-room log cabin, 400 square feet, on the hard-scrabble Virginia frontier, where his father scratched out a living on a small farm. Marshall's only formal education was a single year of grammar school before he joined the Virginia Regiment in 1775 at age 19. So he signs up for this regiment, and the first day he goes there for the first uh, uh, drill, and the commander doesn't show up, who's supposed to drill the troops. So this 19-year-old kid who knew how to use a gun, which was more than most people did, he takes over as the drill master. And he becomes this sort of rising star in the Virginia Regiment. One of his first battles was the Battle of Norfolk. That was the battle in which the British leveled Norfolk, which was then the largest city in Virginia, the largest state in the Union. The image of that city on fire was really burned into Marshall's memory. He witnessed there the fragility of human society and the imperative of a strong military to defend us. It shaped his conservatism. He was a progressive conservative in the mode of Alexander Hamilton and Edmund Burke. He believed in a strong central government to protect the nation's security and the primacy of individual liberty and property rights. He also favored the modernizing influence of commerce, replacing the agrarian slave economy. At Valley Forge, General Washington was so impressed by the young Marshall that he appointed him Judge Advocate General of the Army. And this is before Marshall had even attended law school. And after the military, Marshall follows his sweetheart, Polly Ambler, to Williamsburg, Virginia. And he decides he's got to have an excuse for hanging out in Williamsburg, where he's courting her, and he decides to sign up for some law classes at the College of William and Mary. He attends only 6 weeks of law school lectures. That was the sum total of his legal education. I can assure you that my students are envious of that. And yet, within the decade, Marshall became one of the leading members of the bar in Richmond, Virginia. He was elected to the House of Delegates and appointed the youngest member of the Executive Council of the Commonwealth of Virginia. As a legislator, he fought for laws to liberalize the manumission of slaves and to allow intermarriage between Native Americans and whites. At the Virginia Convention to ratify the Constitution, you have James Madison and John Marshall. They were the two leading proponents for ratifying the Constitution, debating against Patrick Henry, who was the first governor of the Commonwealth, and also, of course, a great hero of the Revolution. Now, Madison was a brilliant theorist, but he was very dour and awkward and frankly kind of nerdy and was not well liked. Marshall was the indispensable man who could schmooze the delegates over drinks at his favorite Richmond tavern. And he managed to persuade just enough delegates that the Constitution passed by a slender margin of just 10 votes. Now, without Marshall, Virginia probably would not have ratified the Constitution. And without Virginia, there would have been no republic. President John Adams decides to send Marshall years later and 2 others, Elbridge Gerry from Massachusetts and Charles Cotesworth Pinckney of South Carolina, on a secret mission to persuade the revolutionary French government to stop interfering with US ships that are carrying goods to Britain. Marshall arrives in Paris in 1797, and there he goes to meet with the French foreign minister, who's the notorious Monsieur Charles Maurice de Talleyrand. And Talleyrand says, as a precondition to negotiate, he wants a bribe in the equivalent amount today of about $6 million, plus a $400 million loan to finance the French war against Britain. Now, Marshall refuses to pay Talleyrand anything, and Talleyrand retaliates by seizing the Americans' passports and refusing to allow them safe passage to leave France. Marshall spends 9 months fighting Talleyrand. All the while, he's living with this charming landlady who may or may not be the illegitimate daughter of Voltaire, Madame de Villette. And Marshall eventually succumbs to her charms, not realizing that she's a spy working for Talleyrand. And I'm going to wait and let you read the book to find out what happens next. But eventually, Marshall returns home to the States, and he's hailed as a hero for standing up to the French demands. And even though Marshall happens to trigger the quasi-war with France in 1798 because of his refusal to deal with Talleyrand, Marshall has no political ambition. All he wants to do now is to return home to his invalid wife, Polly, and their 10 children in Richmond, Virginia. But President Washington insists that Marshall must run for Congress to oppose the growing influence of the Jeffersonians. Washington is now retired, of course, and Marshall agrees reluctantly to the demands of his former commander-in-chief. And he's swept into office and heads to Philadelphia, where Congress is then meeting. In Marshall's single term in Congress, he becomes the leader of the Federalists. But Marshall still wants to return home to Philadelphia. And Adams offers him a way out of Congress by appointing him Secretary of State during Adams' final year in office. Marshall thinks, okay, I'll accept the appointment for 1 year. So then when Adams leaves office, I can leave Washington at the end of Adams' term. And that gives him an excuse to go back home to his wife, he thinks. So imagine the scene. Marshall goes to meet with Adams for the first time at a modest tavern in Washington, D.C. The Capitol is still under construction. And Adams tells Marshall that Abigail doesn't like the swampy climate of Washington, so he's going back home to Quincy, Massachusetts. And he's going to turn over the whole federal government to Marshall to run in his absence. And so Marshall now is in charge of every department of the government except the military. He's in charge of passports, patents, land grants. He runs all of the US attorneys. He oversees the mint, the government press, the census, the territories, and of course, he's in charge of delivering commissions. He also has to supervise the completion of the White House, the Capitol building, and all of the roads and infrastructure for the new city before Congress reconvenes in January for the first time in Washington. At the same time, of course, he's got to manage foreign affairs. France, Spain, Britain, and the Barbary Pirates are all threatening to go to war against the United States. And Marshall has to juggle all of this with a staff of 9 employees and a State Department budget of $15,000, which is just about enough to cover salaries, firewood, and stationery. And he does it all brilliantly. Now, what does it say about a man who rises from poverty with no education to the highest levels of government and the judiciary? I believe that Marshall's genius for self-invention is how he developed a talent for inventing the law. So, all that said, how is he relevant in our current moment? The insurrection on January 6th is still a fresh wound in our country's psyche. It demonstrated both the fragility of democracy as well as the resilience of our institutions of government. But for the courage of the Capitol Police and 62 courts that consistently rejected every attempt to overturn a free and fair election, our Constitution would have been rendered void. Our politics today are no more polarized or more ruthless than the politics of Marshall's day. He faced not one, but two constitutional crises, one precipitated by the Jeffersonians and later by the Jacksonians, both of which were a threat to the independence of our judiciary. What Marshall understood is the need for compromise, and he knew how to forge consensus where none seemed possible. He understood that what transcends partisan politics, what should unite the judiciary, is a commitment to defend the legitimacy and the autonomy of the courts and the rule of law. The courts must be the guardians of the principle that no person is above the law. The independence of our courts is really the linchpin of our liberty. Without it, our republic and our Constitution are lost. So if our liberty depends on the independence of our judiciary, then on whom do we depend when the judiciary itself is under attack, as it has been in the recent past? In the last several decades, we've witnessed pitched battles over the nomination of federal judges. We've seen one former president disparage judges by name, express disdain for the judicial process and for his own attorney general, and insist that he is above the law. We've seen the Senate routinely filibuster the nomination of dozens of qualified judicial nominees. And we've seen some members of Congress threaten to pack the court with like-minded judges. It's not just the political branches that have demeaned and politicized our judiciary. Unfortunately, it's also some judges whose behavior has cast doubt on their own legitimacy as neutral arbiters of the law. The job of a judge or a justice of the Supreme Court is to set aside their political loyalties and decide each case on its own merits. But when lawyers and law students can readily predict with astounding accuracy how certain justices will vote even before a case is heard, it suggests that those judges are putting party loyalty before the law. When the public perceives that the court is really divided between the red team and the blue team, it undermines the public's respect for the judiciary more and more often. As a professor of constitutional law, I find myself struggling to convince a skeptical class that the courts are about something more than party politics. The legitimacy of our judiciary is at stake if judges cannot set aside partisan politics and find common ground. And I know that that sounds naive. I know that even suggesting it's a possibility sounds crazy. But we have to find common ground. John Marshall also lived in a highly partisan moment, and yet as Chief Justice, he found common ground by nurturing institutional loyalty. Every judge and every justice has something at stake beyond the party's political aims, and that is the legitimacy of the court itself. We need justices and judges who will strengthen the judiciary by setting aside their political preferences and leaning in towards the center. We need jurists who hold their truths lightly in the common pursuit of consensus, who prefer compromise to confrontation, and who appreciate that moderation is a virtue. John Marshall was such a man. He had the courage of his imagination, the wisdom to find common ground, and the grace to hold together a fragile union. Thank you.
Thank you, Dr. Paul. That was awesome. And I'm going to read you a comment here. If you haven't seen it before, I happen to agree with our friend Rocco, who is an attorney. He goes, "Thank you for explaining Constitutional Law 101. Took this in law school, and you explained what no law professor would ever do. Now I finally understand what the case was about and the subtle importance of Marbury versus Madison. So thank you very much for that."
Rocco.
As you were talking about Marbury versus Madison, and I know you do this in your book time, you certainly have great admiration for Marshall, but you also point out that he wasn't perfect. He had his foibles and flaws. As you're describing this, certainly what he did with Marbury et al. Was legal, and ultimately it was probably very prudent and wise. Was it ethical?
Good question. Certainly by our contemporary standards, it was not ethical. In fact, a lot of what Marshall did as justice, frankly, would not meet our contemporary ethical standards. He was, for example, indirectly, a party in the suit involved in the Martin case. It was actually his own interests which were at stake in that case, and yet he collaborated with Justice Story in writing the opinion in that case. So he clearly did not play by the same ethical standards that we would play by today. It probably is not a sufficient justification to say that what he was facing in his day, as I explained, is that he was really facing a threat to the survival of an independent judiciary. I mean, what Jefferson and his party wanted to do was to literally impeach every Federalist judge, replace them with like-minded judges, and basically turn the court into their sort of political machine. And that's what Marshall was facing. And so through sleight of hand in the Marbury case, he was able to come out with an opinion which basically made both the Federalists and also the Republicans happy. The Republicans didn't object to his decision because he didn't say that Marbury had a right to be a justice of the peace. He denied Marbury what he wanted, but he also sent this sort of signal to Jefferson and to the Jeffersonians in Congress that the Supreme Court was the final arbiter of the law, which is something that we all now accept as a basic principle. Now, the thing that he did in collaborating with his brother to basically, I mean, in a sense, his brother perjured himself by asserting that he was the person who would have delivered the commissions. But what he did was to establish something that everybody in the whole country understood. I mean, it was understood that, in fact, the commission had been issued, that Marbury would have been entitled to the commission, but the commission was sitting on Madison's desk, and Madison wasn't going to turn it over to the court. So it was a little white lie, in a sense, that enabled the court to introduce into evidence what everybody understood was true in order to accomplish, I think, the goal of preserving the court's autonomy and independence.
Yep. Your introduction was brilliant. I mean, the way you led into this and talking about the country at the time and saying, I'm talking about, of course, Thomas Jefferson. In your book, you certainly take Jefferson to task. What besides the to personal animosity because of family relations between Jefferson and Marshall. Um, describe your feelings towards Jefferson in your book. He was not your favorite.
No, Jefferson was not my favorite. I have been accused of basically throwing Jefferson under the bus, as one critic said, and I plead guilty to that. And here's why. I think Jefferson was a brilliant writer. And if he just was a writer, I think we all would have admired him for his writing. And he created a great university in the University of Virginia. But I think he stole a lot of the credit that belonged to other people like John Adams. Um, uh, his contributions, I think, to the revolution have to be weighed against his conniving with the French. I mean, literally, when Jefferson was serving as Secretary of State, he was secretly meeting with the French ambassador, the citizen Genet, and plotting to start a war with Spain over Mexico, which was exactly the same crime he later accused Aaron Burr of. He was completely disloyal to Washington and to Adams as vice president. He leaked secret memoranda and documents from cabinet meetings, turned them over to the French. He was ruthless towards his political rivals. He paid people to slander and libel John Adams' reputation. He set Aaron Burr up, his vice president. He framed his vice president, accusing him falsely of treason based on a document, a letter that Jefferson knew was a fake. And the penalty for treason, of course, would have been hanging. He was prepared to hang his own vice president. He was a much better writer than a political leader. And his eloquence in the Declaration of Independence was not matched by his service during the war. He was governor of the Commonwealth of Virginia during the Revolution. And when John Marshall went to his cousin and told his cousin, we need more troops to defend the Commonwealth, Jefferson said, I'm too busy planning the new capital in Richmond. I can't be bothered. And the result was the British invaded. They burned the capital. They invaded his house, and Jefferson just ran away. That was his service during the war. He was even Patrick Henry introduced a motion of censure against Jefferson in Virginia because of his service during the war. And the only reason it didn't pass was because basically Jefferson left office and never ran again for office in the Commonwealth of Virginia. And finally, Jefferson could rhapsodize all he wants about revolution and equality, but he really lacked conviction when it came to slavery, and that was one issue which really divides him from Marshall.
Which leads to my next question. How did Marshall view slavery? Obviously, this is something that went on throughout his 34 years. And you mentioned that he favored manumission, but what did Marshall, what was his personal views on slavery?
Yeah, so Marshall doesn't have clean hands, first of all. Marshall owned at least 15 enslaved persons that we know about who worked in his household. But his record, both as a Virginia legislator and also his service as Supreme Court Justice, shows that he was consistently opposed to slavery. And it may seem, hypocritical to folks. Why were you owning slaves while you oppose slavery? And the simple answer to the question is because at the time in 1800 Virginia, there was no free labor market. You couldn't hire a nanny to take care of your kids or hire a housekeeper for your home because there weren't jobs like that. You either had an enslaved person or you did it yourself. Marshall had 10 children and an invalid wife, and he was away from home much of the time. And so he needed someone to do work around his household. And so he had slaves, but for everything we know, he treated his slaves very humanely. They were not what you think of as slavery in the sort of gone with the wind plantation sense of slavery. They had their own homes. They owned land, or they at least were leased land where they grew their own vegetables. Many of them could sell their labor to other people so they could earn income. Um, some of his slaves we know were married and had children and families of their own. And so they were more like indentured servants in many ways than what we think of in terms of plantation slavery. There wasn't a cruel overlord. They weren't beaten. Marshall paid for their medical bills. And we know that he offered manumission to at least one of his slaves. And the slave instead chose to continue to serve his daughter after Marshall's death.
Got a question here, kind of two of them in a way. How would you categorize Marshall's response to Andrew Jackson's overruling of the McCulloch versus Maryland case, specifically Jackson's assertion that the Bank of the United States was unconstitutional, despite Marshall's majority ruling in 1819?
How would I characterize? I missed the first part, Mark, of the question.
How would you categorize Marshall's response to Andrew Jackson's overruling of the McCulloch versus Maryland case, specifically Jackson's assertion that the Bank of the United States was unconstitutional, despite Marshall's majority ruling in 1819?
Right. Yeah. Okay. I'm sorry. I didn't hear the first part of the question. Yeah. So that's a great question. I'm actually, as it happens, the book that I'm working on at the moment is all about that issue. It's about Jackson and the rise of nationalism in America prior to the Civil War. But Jackson was basically wrong on the question about the legitimacy of the court, and most people understood that at the time. Madison, for example, who had initially opposed the creation of a national bank under Washington. He opposed Alexander Hamilton's plan. Later came around after the War of 1812, when Madison needed a national bank to decide that, well, a national bank is constitutional after all. So even though Madison, the principal author of the original draft of the Constitution, had his doubts about the national bank, he came around to view that as a perfectly legitimate way in which to function. Jackson hated the national bank, but Jackson hated banks generally, and he was sort of he didn't understand much about economics, and he didn't like the idea of people earning a living based on finance, and that was really where Jackson was coming from. But his views about the Constitution were simply wrong.
Hey, it's because of Jackson that I memorized about Nicholas Biddle. So I think, as you're talking about your upcoming book, talking about the rise of nationalism, and you mentioned about January 6th, something. Put into context today versus then, and you talked about the, here comes a new, the fourth Chief Justice of the Supreme Court in 1801 with a new president who's very, very political and very politicized. And I mean, if we go back into a time machine, what's going on in 1801 versus 1828 versus 2021? How would you compare and contrast the eras?
Yeah, that's a great question, Mark. what what's what is what's 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 astounding about our present political moment is this. As I explained, 1801 uh, was about as revolutionary a disjuncture, a disruption in the political order as one could ever imagine, having Thomas Jefferson elected president. And yet, what we saw in 1801 was a peaceful transfer of power between two radically opposed parties. I mean, Jefferson hadn't even supported the Constitution when the Constitution was being debated. Jefferson was thought to be opposed to the Constitution and opposed to the national government. And he had celebrated the bloodletting of the French Revolution. And so the Federalists had every reason to fear Jefferson's election, but there was a peaceful transfer of power. And there was a peaceful transfer of power when Jackson took over from John Quincy Adams in 1828. I mean, and that too was a very, very bitterly fought election, a very divisive moment in the country's history. And when Abraham Lincoln took over, we saw again, a moment where the transfer of power was peaceful, even if the country fell apart. What happened on January 6th was just something that is completely without precedent in our history, and God forbid it ever happens again. But it's something that should really, I think, strike fear in everyone's heart, because what it really shows is the fragility of democracy and the importance of, of loyalty to our institutions. And fortunately, in that instance, our institutions held up. And we have to hope that they hold up next time.
Um, Ongoing debate about expanding the court. You have any thoughts on that? Or is 9 justices enough? Should we have more? Should we have less?
Well, as a historian, I have to say that there's no magic to the number 9. We've literally gone from 6 justices to 5 justices. That when Jefferson was elected, the Federalists decided to shrink the size of the Supreme Court to deny him the opportunity to appoint someone. The Republicans then expanded the court to 6. Then it went up to 7, so they could have an extra justice to appoint. Then it went up to 9. Then it went up to 10. Then it went back down to 7. Then it went back up to 9. So we've been up all over the map, and it is not at all unusual for change in political parties to contemplate the possibility of expanding or contracting the size of the Supreme Court. The Constitution says nothing about how many justices there should be. Obviously, the risk is that if the Democrats decide that they want to appoint a couple more justices to even up the score, because they in effect were, many Democrats feel that they were stolen, the 2 seats were stolen from them, then you risk the possibility of an unending escalation, expanding the court, every time the party changes, every time the Washington White House changes hands. And that would make the court unwieldy. So I think that what we really need to do is we need to take a breath, and we need to look at the court and look at the process by which justices are being chosen. The reason that we fight so intently over the court these days, the intensity of that fight is a reflection of John Marshall's success at elevating the importance of the court. In John Marshall's time, they couldn't draft people to be on the court, literally. And now we're fighting to keep people off the court. And so I think what needs to happen is that we need to take a page from some other Western democracies. Other Western democracies like Britain, France, Italy have a process by which judges both to the lower courts as well as to the Constitutional Court, are chosen by other judges. Not exclusively by judges, typically in some kind of cooperative way with the parliament and the prime minister and the judges all working together. And it seems to me that if you create a process by which judges are chosen, that's one way of trying to um, make the process a little bit less politicized. Secondly, I think you have to get a pledge from justices not to serve for life. I think this life tenure thing, it was safe for the founding fathers to say that when people didn't live very long. But today, when we have judges routinely living into their 80s and beyond, it becomes, I think, important to say that enough is enough. And when someone gets appointed to the court, I think they should take a pledge that they're not going to serve longer than 8, 10, 12, whatever, 20 years, whatever it is, so that we don't feel like everything is at stake for a whole generation because of the people who are appointed now in the court and can serve for life. We might also have a minimum age requirement for the same reason. And finally, I think the court has to, Congress rather, has to address the issue of the filibuster, because I think that the filibuster rule has been so badly abused by both parties. And it's necessary to have a filibuster rule, in my view, because I think that you need some protection for the minority party when things get out of hand. And I think that what you might be able to do is to kind of reach a kind of grand bargain where in exchange for an agreement to keep the filibuster, but to reform the filibuster so that when people want a filibuster, they have to give something up. Maybe give up their seniority on a congressional committee, for example, or give up participation on a congressional committee. If that was what the senators had to sacrifice in order to filibuster, then they would only filibuster those things that they really, really felt strongly about. And in exchange for that, and for a process for appointing judges that was less politicized, perhaps you could get an agreement by both parties to increase the size of the court by a couple of judges to kind of rebalance things. So the conservative members of the court would still be in the majority, but they wouldn't have a kind of supermajority that they have now.
One last question I got to ask, because you mentioned this to me in an email, and I got to ask you about this. So I heard you wrote a musical based on your previous book. So let people know about that.
Sure. Many of you are aspiring producers out there. My previous book is a book called Unlikely Allies. It's the story of how a Connecticut shopkeeper, Silas Dean, and a French comic playwright, Caron de Beaumarchais, and a cross-dressing French spy by the name of Chevalier d'Eon get together, and they manage to forge the Franco-American alliance during the American Revolution. They were responsible for smuggling all of the arms, all of the ammunition, all of the uniforms, supplies that American troops had during the Revolutionary War out of France through the British lines to the Americans in time for the critical Battle of Saratoga. And it's a crazy book. It's a crazy story about in which all of this is made possible because the Chevalier d'Eon falls in love with Beaumarchais and decides to admit to him that he is in fact a woman who has spent the first 40 years of her life pretending to be a man and is in fact a woman. And as a man, the Chevalier succeeded both as a spy, a general, and a diplomat, and was serving at the time as ambassador to London. Someone thought it would make a great musical, and so we wrote the music for it, and we're sort of shopping it around, trying to find a producer at the moment. If anyone's interested in hearing the music, it's available on YouTube. If you look for Unlikely Allies, the musical, you can listen to it.
Awesome. So, thank you very much for doing this tonight. I do hope that, now that vaccines are out and things that the COVID skies to be brightening, that you do make it to Harwichport. When you do, please let me know, and I'd love to have you in person so we could actually do this, in the traditional setting, not necessarily by Zoom. Although this was great, I really appreciate you doing this. So thank you for taking the time. I really enjoyed this. This was great. So thank you so very, very much.
Thank you very much, Mark, and thank everybody for participating this evening. I hope I'll get a chance to take you up on that offer, Mark.
All right. Thank you, everybody, for joining us. Thank you, Dr. Paul, for doing this. Good night, everyone, and good luck with the book. Thank you.
Thanks.